Welcome to the Digital Planning Podcast. This series is designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. To keep up with all things digital, please subscribe at iTunes, Stitcher, Google Play, or wherever you download your podcasts. And now, Jennifer Ziegel, a partner at Kleinbart LLC, Ross Bruck, a principal of Estate Genie, and Justin Brown, a partner at Pepper Hamilton LLP, with today's topic.
Welcome back to the Digital Planning Podcast. I'm your host, Jen, and with me today is my podcast partner, Justin. And unfortunately, our other team member, Ross, is not available to be here today because he has a work conflicts. However, we have something very special planned for you because we will be interviewing Sharon Hartung. Now, Sharon is the founder and principal of Your Digital Undertaker, and Sharon has over 30 years of experience in IT management, project management, and consulting. Sharon utilizes a multidisciplinary approach to educate and assist people in better understanding the role of managing digital assets in estate planning and estate administration. Sharon has built and maintained large enterprise systems in both the public sector and for financial clients. Sharon spent a large portion of her career as an executive and consultant in project management for IBM Global Services. Sharon's book, Your Digital Undertaker, Exploring Death in the Digital Age in Canada, was recently published. Sharon is also a Society of Trust and Estate Practitioners, STEP, affiliate and committee member of the STEP Global Digital Assets Special Interest Group. Welcome, Sharon. Thank you so much for being here with us today.
Thanks so much, Jen and Justin. I really appreciate being here today.
So Sharon, how did you get interested in exploring digital assets?
Really interesting question when you're talking to someone from information technology. Now, my journey into the estate world and digital assets didn't start with technology, as you might expect. It started when my mom died without a will. And when I was dealing with her estate, I came to realize the big job of the executor, and somehow we really haven't learned to talk about death. So the journey started by trying to crack the code of my mother's estate, but once I started to realize the transformative impact technology and digital assets were about to have on the estate industry, my new vocation was born.
So you have a large background in technology, and you're stemming that into exploring digital assets. How did that marriage, really get effectuated as part of your mother's estate administration process?
Certainly, my experience started with technology as an aerospace engineering officer, where I managed embedded system projects, and from there I went to IBM, where I ran projects for clients in the public and private sector. I had a variety of roles in project management, from leading projects to quality and risk management, and an interesting tour of duty running a division for our outsourcing group, where clients would hire us to maintain systems. But when I was dealing with my mother's estate, I couldn't find a basic how-to manual and anything that was written for the pre-digital world. And when I was an executive at IBM, I learned it wasn't about understanding the process. What was really important was documenting the processes so others could understand it. So that's how I've taken those skills and used them to document this universal process, and obviously with the digital side.
So Sharon, was your mother's death the motivation for this book?
It was definitely the pivotal event that unfolded, and as I mentioned, working through her estate, I began to realize that although I've run large projects at IBM and in the Air Force, I had no idea what a big project executor's role is. And when you start to layer on the fact that we have completely gone digital in our online lives, I began to realize, the industry might need some help from a professional like myself who could understand project management and IT to kind of rethink about the role of the executor.
Well, it's so interesting because a lot of people who are in the estates world started in the estates world, and you really didn't. You started in the tech world and came into this world.
You're a transplant.
Absolutely. But having said that, in the estate world, as you know, estate lawyers and estate planners will often consult with advisors of different types depending on what physical assets they're dealing with. So you might deal with a real estate agent if you're trying to deal with property. You might deal with a tax advisor who has expertise in tax. And now we have a new set of assets called digital assets. and the executor's role has fundamentally changed because there's no longer a paper trail. We have a new player at the table, the technology advisor in estate planning.
And for listeners who are just joining our podcast, maybe for the first time, you can go back and look at the history of different episodes we've done where we take a deep dive into exploring what digital assets really are and the various definitions there too. So Sharon, going back to your mother's estate, did you uncover digital assets that she owned?
Yes, but I was lucky. Simply in her case, it was one email account which she had left written on a nice piece of paper in her beautiful handwriting, and she hadn't used it in a long time, so it had expired. So fortunately, my digital undertaking role didn't have to come to play. But I spent almost 2 years, and it finally wrapped up in 2.5 years, dealing with the fact, first of all, she didn't have a will. So I had to apply for the courts, as you know, from a legal perspective, what's involved there. And then the multifaceted project that unfolds, the tax, the inventories, collecting the properties, trying to determine where things are and how to deal with that. And when you add now our digital lives on top of that, we've just made the executor's role even more complicated. I think, Justin, you covered this in your estate administration podcast, talking about just how fundamentally the role of executors and corporate executors and advisors to executors' roles are going to change as a result of the digital age.
Yeah, I think it's going to change immensely as more and more digital assets are uncovered, and fiduciary duties with respect to those assets. So we're glad to see somebody like you writing about this and bringing attention to digital assets in estate planning and estate administration.
Well, it's definitely a new territory in green, but the great thing that I found about being in the estate planning world, it's a team sport, so there's going to be a lot of interaction between technical people, estate lawyers, and tax people and other advisors as we try to navigate this whole issue together.
That's definitely one of the trends in general with estate planning and administration. Are you seeing any other trends, in connection with this digital administration and planning space in Canada?
I'd say this is more a global statement, but I see trends on several spectrums. I can give you 3 off the top from a technology point of view. Number one, digital assets, which you know so well. There's no question we're going to need processes, or I call it tech to manage our tech, from estate planning to estate administration. We just have too many online accounts. So if we take digital asset management itself, we are seeing emerging tech entrepreneurs in this space. I co-wrote an article with Shelley Rhodes Perry in the July Step Journal called Bolster Your Digital Armory, around trying to relay a picture with a spectrum of the emerging types of tech tools. The second thing I'm seeing is the need for financial institutions, the estate industry, to optimize their internal processes, not only for cost efficiency, but customer engagement. The software to improve the will creation process, the software to reduce the burden on the estate administration, from inventories to tracking. And then the third thing I'm seeing is the emerging demands of the customer-driven marketplace. Consumers are going to look for the same ease of engagement in dealing with the death care and estate industry as they do with any other industry, and using apps and social media. I've called this Estate 2K, the massive transformation about to hit the death care and estate industry. I call it estate tech. It's going to be about the size of fintech if you consider we're on the cusp of the largest wealth transfer in history. And I think what's going to fuel that as well is the more open conversation of the death positive movement. If you look on Twitter, it's hashtag death positive. It's large in Europe, UK in particular, and emerging in the US and other places like Australia. You might have heard of death cafes, which started in the UK, that are now global, an open conversation about death and dying and end-of-life issues. Australia has a Death Planning Awareness Day, August 8th, called Dying to Know, which is designed to encourage death literacy. Another U.S. example is Kathleen Doughty. She's a mortician and author, started the Order of Good Death. And this death positive movement is injecting a new dialogue about end-of-life planning and how people want to die and be remembered. And if you want to look to 2, U.S. mainstream examples recently, consider the interview by Anderson Cooper of CNN, interviewing Stephen Colbert on overcoming grief and loss as a child, and the HBO special documentary called Alternative Endings, 6 Ways to Die in America. So we're really on the cusp of this transformation with remarried technology and the death positive movement and the conversation about death. You know, everything is going to change, how funerals are going to happen, how people are going to be memorialized, the demands that the millennials will have of the estate industry as executors dealing with financial institutions, and they won't be quiet about it. They'll use social media to talk about if they're getting a positive client engagement through that process.
Sharon, you're absolutely right. We couldn't agree with you more in terms of how society globally is really changing the death care and estate administration movement. I'd never heard of death cafes, so thank you for sharing that with us.
Yeah, it's very interesting. It's just a transformative conversation, and it's really interesting that I think social media as a technology tool and platform has enabled that conversation globally. So people have shared about it and started in other countries. So you can actually go to a death cafe in pretty well any city in the world.
So Sharon, with this global movement for more awareness of death at estate planning, what do you think the hurdles to mass adoption of digital assets and digital asset planning would be?
Very good question. Digital assets, as you know and you've talked about in your podcast, really need pre-planning to successfully not only identify them and transfer them so that you can meet, obviously, the will maker testator's intentions. Justin, you talked about this in a previous podcast, the idea that the executor's role has fundamentally changed. But if we get under the covers of what's changed, you know, physical assets obviously need pre-planning as well, but not to the same degree as digital assets. And the reason is digital assets are virtual. They're not going to show up in the search of a home office. You're going to be unlikely to leave a paper trail. So if the executor is dependent on that paper trail for his or her administration job, there's going to be a challenge. And we've gone online with even our physical assets, so online banking. So I think the biggest hurdle that consumers or will makers are going to have is that we're just not aware, we're not conditioned, or we're not collectively learning from the experiences of others the need to pre-plan as part of estate planning. I mean, if you want to oversimplify estate planning for the average person, it's just getting a will. They may not even have had a conversation with the executor, and they may not have created an inventory list to help the executor figure out what their job is. When you look at this statistically, less than 50% of North Americans have a will, and in Canada, less than 35% have an up-to-date one. So it means we're not talking about death, we're not pre-planning. Digital assets critically need pre-planning. This means that most people are going to leave an executor at disaster in the digital age.
I was going through your book, and there's a good chart in one of your chapters that compares what an executor who goes into an office would look for in 1980 and what an executor would be looking for today. And just going through that chart, it is striking to me how, I mean, it is a great demonstration of how the role of an executor has changed, right? It's looking, in 1980, the person's looking through a Rolodex. People don't have Rolodexes anymore. You know, going through letters on someone's desk, where now you're going through computers or tablets. It's just, I think you did a great job of explaining how the world is changing.
Yeah, I love that diagram because, as you point out, the internet, you know, arguably started 30 years ago, 1989. So as the picture paints, in the 80s we had physical assets, we had paper trail, and we really relied on that paper trail for the executor's job. So we have thwarted the executor now because, you know, 30 years later, everybody's home office or kitchen table is going to have a laptop with a locked password.
Yes, it's the issue of the disappearing paper trail. And Sharon, I did read your book, and I want to say you did a fantastic job writing it, and I love your anecdotes sprinkled throughout. It really breaks up some of the seriousness of the subject matter that you cover in a light way. So very well done. Thank you so much for sharing that with us and the world.
Oh, thanks, Jen. Awesome. Thank you. I appreciate that. Yeah, it's a tough topic. So nothing can transform a topic with a little appropriate humor and certainly diagrams, which all us engineers live for.
So Sharon, with this death movement, and as people like you bring more visibility to digital asset planning, where do you see digital asset planning going in the next 5 to 10 years?
Well, I'd love to have the crystal ball on the blockchain technology because I'd invest in all those companies right away. And you covered blockchain several times in your podcast very well, by the way. And we know the broadest use case is clear. So blockchains allow parties to exchange value in a trusted way without an intermediary and track as you go. Now, if you consider most businesses rely on processes or a system to track transactions of some kind, there's no question this will be transformative. But what we don't know is who's going to be the next Netflix, Uber, and Amazon of blockchain. Now, that's on the technology side. On the the cryptocurrency, the unregulated cryptocurrency is the first instantiation of the blockchain technology. If we consider Facebook announced their own plans for their crypto Libra, certainly there's going to be regulatory considerations, but we would be naive to think that governments haven't started considering the future of fiat currencies and perhaps even the idea of a country-specific crypto. So in terms of digital assets in a state administration, I think in 5 to 7 years we're going to have a crisis on our hands in the state administration for the two reasons that we've been discussing. New set of assets, digital assets, and then over the last 10 years in an accelerated manner, businesses have literally driven us online for banking, paying bills and statements, and there's no longer the paper trail. And collectively, the industry hasn't really raised the alarm with our clients. We've not been really talking about this extensively, except for the last 5, maybe arguably 10 years. So our money, our memories, and our records are now virtual versus physical. The law and the courts have yet to see the hundreds or thousands of families that are going to be upset because they can't transfer loyalty points or they can't get access to family photos. And so far, we've only seen the one-off cases. And with the acceleration of our use of the internet, the size of the problem is only going to grow.
So in the United States, the Uniform Law Commission created model legislation, a second attempt. It's called RUFADA, which is the Revised Uniform Fiduciary Access to Digital Assets Act. And this legislation was created so states can adopt it as a way to fill gaps left in pre-existing federal and state laws that don't allow for a fiduciary to access a decedent's digital assets. And the default rules under RUFADA require a user, an individual, to specifically authorize a fiduciary's access to digital assets. That can be done through an online tool, which is a separate service agreement with the user and the custodian, specifically authorizing that type of access to named individuals. If there is no online tool, it can be done through estate planning documents that would allow that authorization. And if there is no estate planning documents with that requisite authorization, the terms of service agreements control, which could have various outcomes. Is there any default rule in Canada on accessing a decedent's digital assets, similar to RUFADA?
Well, I can give you the layperson's answer because I am the information technology advisor and not the Canadian lawyer. But first, I'll say this. So, when most of us think about our estate plan and our wills, this is a layperson's perspective. We don't really realize all the laws and rules that apply. And certainly when you're in estate planning, you understand that there's wills law that tells you, how a will can be valid. There's intestacy and succession law that deals with what happens if you don't have a will. The idea that there are executor-specific rules, as in the U.S. being most of the U.S. states adopting RUFADA, is not something people are generally going to understand. So I just wanted to share that because, from my layman's point of view, the average consumer out there has no idea of the implications of the law that was implemented in the U.S. Now, in Canada, the Uniform Conference Law of Canada proposed legislation in 2016. It's called Uniform Access to Digital Assets by Fiduciaries Act. Doesn't have a nice roll on your tongue acronym like RUFADA. So it was proposed for adoption in all provinces and territories, and it really codifies the right of the fiduciary to access digital assets with the same rights they have to access physical assets. So, the layman's interpretation, this extends what you're already allowed to do for physical for your digital world. Now, the proposed Canadian legislation has not been adopted by any province or territory. Now, similar to the U.S. states, our state law is at the provincial or territorial level, so we're similar in that respect. Now, the U.S. and Canada all started with the same starting point, but as you know, as you've explained, the U.S. legislation, when mostly in most U.S. states, was adopted the revised RFADA, which had the big turn in it, which requires this pre-planning, which we haven't seen before in the state legislation. Now, there is a reason Canadians or anyone globally actually needs to pay attention to the U.S. rules. If you consider a lot of people use Google's email, for example, or where many of the big tech providers are, even if you have the right in Canada, supposing our legislation gets adopted in the province that you're dealing with, there's going to be a conflict of law question if you can actually get access. Because when I look at the Google Terms of Service, if you don't have a password, it says you're going to need a U.S. coilover. So to answer your question, this is where the Canadian proposed law is going, that says that extends the executor's rights to deal in the same way they do with physical assets, not yet adopted. But I guess the question that comes for me as a project manager and executor advising project managers is that we'll now need to look at these digital assets that may cross borders. There's a conflict of law question here too.
I think that's a great point, because I think we as U.S. attorneys tend to get into our tunnel of U.S. law, and we don't always think about what somebody abroad is going to be encountering when they're running into a Gmail account or a Google account that's sitused in the United States. So I think that's a great point. I was wondering, we are hearing more and more of the term digital executor in connection with estate planning, and I mean, your book is called Your Digital Undertaker. So can you describe to us a little bit about, for the people who haven't read your book, what you mean by digital undertaker and how that overlaps with a digital executor?
Okay, certainly. Your Digital Undertaker as a title was selected because I really wanted to gain the attention of people to talk about this important topic of estate planning. I cycled through a lot of different project and project-related titles or sort of traditional estate planning titles, and I wanted something that really embodied the fact that our estates have gone digital. Although the book covers all the elements of estate planning, there's a digital element to everything now. And I wanted to pick a term that would garner some reaction, and that's why I picked the Undertaker term. And the Your was to more personalize it because, as you know, as estate planning attorneys and estate administration attorneys, it's a personal journey. Everybody's situation is different from the next, and it's your estate plan. Now, I'll shift to talking about digital executor, and Jen knows that I have a very strong opinion on this term, and I have a very strong opinion about this from a project management point of view, because I believe the term digital executor is just made-up term and could cause massive confusion. Now, it's certainly great to raise the awareness that the future executor in a will has a role, but it can become confusing. Our digital lives are so interconnected with our physical lives, it's really difficult to separate the two. And in the book, I give a project management scenarios about how complicated naming a digital executor and an executor can get in sort of execution, outside the law. And the reason this is, several-fold. First, the executor, any future executor, is going to need to have some basic technology skills if you consider that everyone's using email. And two, I look at it from a point of view that, like an art collection, there may be specific assets that you need more expertise than the executor has, and how would you deal with those in a regular estate planning situation? So, say you had an art collection or a coin collection, the executor might engage an appraiser or an advisor. The same principle can apply here, this time with a technical advisor. Or if you as a testator or will maker have, a very specific digital asset, say you do have one of the unregulated cryptocurrencies, and the executor you pick you may not feel as qualified, you may put provisions in your will that appoint someone very specifically to deal with those. But the idea that you would say, your digital executor deals with your digital life and your executor deals with your physical life means the two are going to be in absolute conflict. The other chicken or egg scenario I give is, if your laptop as a physical asset is not considered a digital asset, but the photos on it are digital, and you've got these two people, how does that work? So I've sort of looked at this from a project management point of view and said, we need to be really careful with the terminology.
Sharon, I echo everything you have said, and as we've discussed in private, I completely agree with all of your concerns just from a straight administrative perspective on naming somebody as a digital executor in a will, and physical assets and digital assets are so intertwined that it could be extremely difficult for administration issues. From a legal perspective, and Justin and I have begun to look at this more closely. We don't know in terms of United States Register of Wills or surrogates offices or similar bodies in different states within the United States would actually react to an executor and a digital executor being appointed in a will and issuing short certificates to document that type of appointment. And there can be a lot of competing interests among both the digital executor and the main executor on who can do what, or valuation and timing issues of digitally connected assets. For estate planning attorneys, in terms of techniques for drafting, I think at this point in time it's actually a lot better to maybe appoint a digital committee that the executor could rely upon or engage for assistance with managing digital assets, but those individuals would not rise to the level of a executor position.
Sharon, to your point about how digital executor is just a made-up term, I think that is one of the reasons why there are problems in the United States with going to the various surrogates and register of wills, because there is no legal definition of a digital executor. So they will all view your digital assets as different things, right? Some may view your social media accounts as digital assets, and some may view your cryptocurrency as digital assets, whereas some may view the cryptocurrency as part of your probate estate.
Right, as intangible personal property, as it's currently defined under the internal, by the IRS.
So for those people who are using a, quote, digital executor, we think it kind of opens you up to potential ambiguities and potential problems down the road. I think that's why having an advisory committee is kind of another way to go that can accomplish what you want to accomplish and not run afoul of the probate laws.
Yeah, I couldn't agree more. Now, just from the basic project management perspective, I look at the executor's role being the project manager, and you have a multiple number of assets you have to deal with. It's going to get very confusing when certain definitions of what is a digital asset versus not. In Canada, from a tax perspective, there's only one estate. So if different people are named, how do taxes get deal with it? What's the logistics of it? So, from a project management point of view, I look at this and basically say, there's a construct that works here. We have a will, we have an appointed executor. The idea that we have different kinds of assets and the executor needs help, absolutely. There's, as you point out, there's advisory committees. There's different ways you can meet the needs that the executor will have so that it doesn't confuse who's the boss, who's on first to deal with the entire estate. Now, there's one other area, too, that's really interesting, and you've talked about it in previous podcasts as well, is the idea, and I think this is going to be another area we're really going to have to figure out how to deal with as well, is there's no question that we need more pre-planning opportunities, and one of the easiest one that providers can give us, software providers and we have examples of Facebook and Google, is where someone is appointed in the contractual way that is allowed to do something. The terminology is not consistent. Facebook says it's a legacy contact, and Google uses an inactive manager. In a way, this is kind of like a beneficiary designation, but not really. It's kind of a digital executor, but not really. So the law is going to have to also help us deal with, what is that person, and to what extent do they have responsibilities only to meet the contractual responsibility of the agreement. If a digital asset, for example, is allowed to appoint potentially a legacy contact that has some financial value, who has to deal with taxes. So there's another project management level here that we're going to have to get our heads around as we deal with the technology side.
So the Facebook and Google designations that you're speaking of under RUFADA, that's lumped together as an online tool, even though they're calling it different terms. But that's essentially what it is, because there's a separate agreement between the user and the service provider to allow that designation or authorization to the digital assets. And we completely agree with you that there's going to be a lot of competing interests if the person who is named in the online tool to have access or authority over the digital asset is different than the person named as the fiduciary in estate planning documents. There can be so many different situations that come up in a lot of litigation surrounding that issue. I mean, one in particular that comes up with Google is if a person that was designated as the inactive account manager who can access the emails and information is different than the executor named in the document, but if there's information within the emails within the Google account that is required in order to access other property or digital assets that aren't controlled by that online tool, does that person who's designated in the online tool have any responsibility to provide said information? And right now I don't think that they do. Or at least there's nothing in place that would require them to under WFATA. So it's a big issue that has yet to be addressed or come up in terms of cases in the court. But stay tuned, because it definitely will be surfacing its ugly head.
Right, and that one is very interesting unto itself, because email has become our new home office. If you've designated someone as an inactive manager, they potentially have access to all the information the executor named in the will is going to need. So that will cause, some confusion on that front.
So, Sharon, aside from the United States and Canada, are you aware of any other countries that are actively developing practices surrounding digital assets and digital planning?
Well, I'll answer it this way. The STEP Association, the Society of Trust and Estate Practitioners that I'm part of, which is a global organization, has launched a digital asset special interest group in 2017. Any estate planner or estate administrator can join, and you don't need to be a STEP member, and it's free. They've developed jurisdictionally specific guidance and digital asset inventory used with clients. So I know from the representation on our committee that we do have representation from other countries in the globe, from Australia, from Israel. I don't have my list in front of me, but and jurisdictional specific guidance has been written for many jurisdictions, and our new members from different geographies are writing guidance for their specific geography. So that's what I do know about what else is going on globally.
Well, that's all the time we have for today. Thank you very much for tuning in, and stay with us next time as we continue the discussion with Sharon Hartung, author of Your Digital Undertaker, on estate planning and estate administration with digital assets.
Thank you for listening to this episode of the Digital Planning Podcast, the podcast designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. Please subscribe to this podcast and leave us a rating or review at iTunes, Stitcher, Google Play, or wherever you download your podcasts. Thanks for joining us. We'll see you next time.